Minerals and Mining Act, 2006. Act 703. Minerals Property of Republic. Section 1. Every mineral in its natural state in, under, or upon land in Ghana, rivers, streams, watercourses throughout the country, the exclusive economic zone and an area covered by the territorial sea or continental shelf is the property of the Republic and is vested in the President in trust for the people of Ghana. Compulsory acquisition and land. Section 2. Where land is required to secure the development or utilization of a mineral resource, the President may acquire the land or authorize its occupation and use under an applicable enactment for the time being in force. Land available for application for mineral right. Section 3. Land in the country may be made the subject of an application for a mineral right in respect of a mineral specified in the application, other than land which is a. The subject of an existing mineral right in respect of the specified mineral, or b. Expressly reserved, by or under this Act or any other enactment from becoming the subject of a mineral right. Minister may reserve land from mining. Section 4. 1. The Minister may, by executive instrument declared land, not being the subject of a mineral right, to be reserved from a. Becoming the subject of an application for a mineral right for a mineral, or b. Becoming the subject of an application for a mineral right in respect of specified minerals or of all minerals except specified minerals. 2. An executive instrument issued shall be by the authority of the President. Power of Minister to grant mineral rights. Section 5. 1. Subject to subsections 4 and 5. The Minister on behalf of the President and on the recommendation of the Commission may negotiate, grant, revoke, suspend or renew mineral rights in accordance with this Act. 2. Where the Minister grants a mineral right, the Minister shall determine the land subject to the grant. 3. Where the Minister determines not to grant an application or determines to grant an application over a part of the land applied for, the Minister shall give the applicant written reasons. 4. A transaction contract or undertaking involving the grant of a right or concession by or on behalf of a person or body of persons, for the exploitation of a mineral in Ghana shall be subject to ratification by Parliament. 5. Parliament may, by resolution supported by the votes of not less than 2/3 of all the members of Parliament, exempt from the provisions of subsection 4 of this section a particular class of transaction, contract or undertakings. Skip section 6 to 8. Mining activities require mineral rights. Section 9. 1. Despite a right or title which a person may have to land in, upon or under which minerals are situated, a person shall not conduct activities on or over land in Ghana for the search, reconnaissance, prospecting, exploration or mining for a mineral unless the person has been granted a mineral right in accordance with this Act. 2. Activities conducted under a mineral right shall be limited to the activities permitted by the mineral right. 3. Subsection 1 does not prevent a government institution or agency from conducting geological activities in accordance with its powers under an enactment. Qualification for grant of mineral right. Section 10. Unless otherwise provided in this Act, a mineral right shall not be granted to a person unless the person is a body incorporated under the Companies Act. Act 992, under the Incorporated Private Partnerships Act 1962, Act 152, or under an enactment in force. Application for mineral rights. Section 11. An application for a mineral right shall be submitted to the Minerals Commission in the prescribed form and shall be accompanied with a statement providing a. Particulars of the financial and technical resources available to the applicant for the proposed mineral operations. b. An estimate of the amount of money proposed to be spent on the operations. c. Particulars of the program for proposed mineral operations, and d. Particulars of the applicant's proposals with respect to the employment and training in the mining industry of Ghanaians. Recommendation to the Minister. Section 12. The Commission shall, unless delay occurs because of a request for further information from an applicant or a delay is caused by the applicant, submit its Recommendation on an application for a mineral right to the minister within 90 days of receipt of the application. Grant of mineral rights. Section 13. 1. The minister shall within 60 days on receipt of recommendation from the Commission make a decision and notify the applicant in writing of the decision. On the application and where the application is approved, the notice shall include details of the area, the period and the mineral subject to the mineral right. 2. The minister shall, not less than 45 days prior to making a decision, under subsection 1, give a notice in writing of a pending application for the grant of a mineral right in respect of the land to a chief or allodial owner and the relevant district assembly. 3. A notice given under subsection 2 shall a. State the proposed boundaries of the land in relation to which the mineral right is applied for, and b. Be published in 1. A manner customarily acceptable to the areas concerned, and 2. The Gazette and exhibited at the offices of the district assembly within whose district a part of the area is situated. 4. The applicant shall within 60 days of receipt of notification of approval notify the minister in writing of acceptance of the offer of the grant. 5. The minister shall upon receipt of the notification of acceptance of the offer grant the mineral right to the applicant. 6. An approved application shall lapse if the applicant fails to notify the minister of an acceptance in accordance with subsection 4. 7. Subject to the provision of this Act, a mineral right shall be subject to the terms and conditions that are prescribed from time to time. 8. The rights and obligations of a holder of mineral right shall apply to the agents and employees of the holder. 9. Subject to sections 73 and 74, a mineral right granted by the minister under this section is sufficient authority for the holder over the land and entitles the holder to enter the land in respect of which the right is granted. 10. The holder of a mineral right shall not remove or destroy a mineral obtained by the holder in the course of a mineral operations without the permission in writing of the head of the Inspectorate Division of the Commission. 11. Despite subsection 10, cores and samples may be retained by a holder for the purpose of assay, identification or analysis of the mineral. 12. Where a core is retained under subsection 11, the holder shall maintain, in respect of the core or sample, particulars sufficient for the identification of a. The core or sample, and b. The location and geological horizon of its origin, as the head of the Inspectorate Division of the Commission may in consultation with the Director of Geological Survey Department determine. 13. Geological core samples may after assaying, identification or analysis of a mineral be disposed of only with the express consent of the Commission, given in consultation with the Geological Survey Department. Assignment of mineral rights. Section 14. 1. A mineral right shall not in whole or in part be transferred, assigned, mortgaged or otherwise encumbered or dealt in a manner without the prior approval in writing of the minister, which approval shall not be unreasonably withheld or given subject to unreasonable conditions. 2. Where the minister has not given a decision in writing to the applicant within 30 days of receipt of an application for approval, the minister shall upon a request from the applicant give written reasons to the applicant for the failure to communicate a decision on the application. 3. The reasons required under subsection 2 shall be sent to the applicant within 14 days of receipt of the request. 4. A dispute between the minister and an applicant or holder in respect of a decision of the minister under subsection 1 shall be referred for resolution under section 27. 5. Subject to the other provisions of this section, an undivided proportionate part of a mineral right or application for a mineral right may be transferred, assigned, mortgaged or otherwise encumbered or dealt with. Skip section 15. Obligations of holders of mineral rights. Section 16. 1. The holder of a mineral right shall at all times appoint a manager with the requisite qualification and experience to be in charge of that holder's mineral operations. 2. The holder of a mineral right shall notify the head of the Inspectorate Division of the Commission in writing of the appointment of a manager and on each change of the manager. Water right. Section 17. Subject to obtaining the requisite approvals or licenses under the Water Resources Commission Act 1996, Act 552, a holder of a mineral right may, for purposes of or ancillary to the mineral operations, obtain, divert, impound, convey and use water from a river, stream, underground reservoir or watercourse within the land the subject of the mineral right. Forestry and Environmental Protection. Section 18. 1. Before undertaking an activity or operation under a mineral right, the holder of the mineral right shall obtain the necessary approvals and permits required from the Forestry Commission and the Environmental Protection Agency for the protection of natural resources, public health and the environment. 2. Without limiting subsection 1, a holder of a mineral right shall comply with the applicable regulations made under this Act and any other enactment for the protection of the environment insofar as relates to exploitation of minerals. Skip sections 19 to 30. Section 31. Application for a reconnaissance license. 1. Subject to this Act, the Minister may, on an application made by a qualified person and on the recommendation of the Commission, grant a reconnaissance license in respect of all or a part of the area applied for and in respect of all or any of the minerals specified in the application. 2. A reconnaissance license may be granted for an initial period of not more than 12 months. 3. The area of land in respect of which a reconnaissance license may be granted shall be a block or any number not more than 5,000 contiguous blocks each having a side in common with at least one other block the subject of the application. Section 32. Rights of holder of reconnaissance license. 1. Subject to this Act and the regulations made under this Act, a reconnaissance license confers on the holder and a person authorized, in accordance with this Act by the holder of the reconnaissance license, the exclusive right to carry on reconnaissance in the reconnaissance area for the minerals to which the reconnaissance license relates and to conduct other ancillary or incidental activity. 2. For the purposes of exercising the right conferred under subsection 1, a holder of a reconnaissance license and a person authorized in accordance with this Act by the holder of the reconnaissance license may enter the reconnaissance area and erect camps or temporary buildings. 3. A holder of a reconnaissance license shall not engage in a drilling or excavation. Section 33. Application for extension of term of reconnaissance license. 1. A holder of a reconnaissance license may, not later than 3 months before the expiration of the initial term of the license, apply to the Minister for an extension of the term of the reconnaissance license in respect of all or part of the reconnaissance area. 2. The form of the application shall be as may be prescribed. 3. Where an application for extension of the term of a reconnaissance license is made under this section and the applicant has materially complied with the obligations imposed by this Act with respect to a. The holding of the license, and b. The activities to be conducted under the license, the Minister shall extend the term of the license. 4. Subject to subsection 5, a reconnaissance license may be extended once only and for a period not exceeding 12 months. 5. Where, at least 1 month before the end of the extended period, or within the shorter period that the Minister may allow, the holder of a reconnaissance license satisfies the Minister that delay by a government institution in the issuance of a permit or in carrying out a lawful activity has resulted in delay by the holder in the discharge of an obligation under the reconnaissance license. The holder may apply in writing to the Minister for extension and the Minister may extend the term of the reconnaissance license for a period of not more than 12 months. 6. Where a holder of a reconnaissance license has made an application for an extension of a. The term of the license, or b. The land and for some or all of the minerals the subject of the reconnaissance license, and the term of the reconnaissance license would but for this subsection expire, the reconnaissance license shall continue in force with respect to the land or minerals the subject of the application until the application is determined. 7. If the holder of a reconnaissance license transfers the reconnaissance license in accordance with this Act after making an application for a. An extension of the term of the license, or b. A prospecting license or mining lease in respect of all or part of the land and for some or all of the minerals the subject of the reconnaissance license, the application shall continue in the name of the transferee, as if the transferee had made it. Section 34. Application for prospecting license. 1. The Minister may, on an application duly made by a qualified person and on the recommendation of the Commission, grant a prospecting license in respect of all or any of the minerals specified in the application. 2. A prospecting license shall be granted for an initial period not exceeding 3 years. 3. The area of land in respect of which a prospecting license may be granted shall be a block or a number not exceeding 750 contiguous blocks, each having a side in common with at least one other block the subject of the application. 4. If a holder of a reconnaissance license applies for a prospecting license over all or part of the land and for a mineral the subject of the reconnaissance license, and the holder has materially complied with the obligations imposed by this Act with respect to a. The holding of the license, and b. The activities to be conducted under the license. The minister shall within 60 days of the application, subject to the permits and other obligations required by law having been complied with, grant the applicant the prospecting license on the conditions that shall be specified in the license. 5. A dispute between the minister and a holder in respect of any matter that arises under subsection 4 shall be referred for resolution under section 27. Section 35. Extension of the term of a prospecting license. 1. The holder of a prospecting license may, at any time but not later than 3 months before the expiration of the initial term of the license, apply in the form that may be prescribed to the minister for an extension of the term of the prospecting license subject to section 38, 3, for a further period not more than 3 years in respect of all or any number of blocks the subject of the prospecting license. 2. On an application duly made under subsection 1, and upon being satisfied that the holder has complied with the obligations imposed by this Act with respect to a. The holding of the license, and b. The activities to be conducted under the prospecting license. The minister shall on the recommendations of the Commission grant an extension of the term of the prospecting license. 3. A dispute between the minister and a holder in respect of a matter that arises under subsection 2 shall be resolved under section 27. 4. Where a holder of a prospecting license has made an application for an extension of the license and the term of the prospecting license would, but for this subsection expire, the prospecting license shall continue in force in respect of the land the subject of the application until the application is determined. 5. Where a holder of a prospecting license has made an application for a mining lease and the term of the prospecting license would, but for this subsection expire, the license shall continue in force with respect to the land and minerals the subject of the application until the application is determined. 6. If the holder of a prospecting license transfers the prospecting license in accordance with this Act after making an application for a. The extension of the term of the prospecting license, or b. The mining lease in respect of all or part of the land and for some or all of the minerals the subject of the prospecting license, the application shall continue in the name of the transferee as if the transferee had made the application. Section 36. Program of Prospecting Operations. 1. A prospecting license may not be granted unless the proposed program of mineral operations submitted with the application is, in the minister's reasonable opinion, suitable in the circumstances. 2. The holder of a prospecting license shall notify the minister of an amendment the holder wishes to make to the program of prospecting operations, and the amendment shall, unless rejected by the minister on reasonable grounds, within 2 months after receipt of the notice, have effect after that period. 3. The minister may, upon an application made by the holder of a prospecting license, limit or suspend the obligation of the holder to carry on prospecting operations, under terms and conditions that the minister may reasonably determine. 4. A dispute between the minister and a holder in respect of a matter that arises under subsection 1 or 2 shall be resolved under section 27. Section 37. Rights and obligations of a prospecting license. 1. The holder of a prospecting license may, in the exercise of the rights under the license, enter upon land to which the license relates to a. Prospect for the mineral in respect of which the license is granted. b. Make boreholes and excavations that may be necessary for the prospecting purposes. c. Erect camps and put up temporary buildings necessary for the prospecting operations, and d. Conduct other activity ancillary or incidental to the prospecting. 2. The holder of a prospecting license shall a. Commence prospecting operation within 3 months after the date of the issue of the license, or at a time specified by the minister. b. Demarcate and keep demarcated the prospecting area in the prescribed manner. c. Carry on prospecting operation in accordance with the program of prospecting operations. d. Notify the minister through the Commission of any discovery of minerals to which the Prospecting license relates within a period of 30 days from the date of the discovery. E. Notify the minister through the commission of the discovery of a mineral deposit which is of possible economic value within a period of 30 days from the date of the discovery. F. Fill back or otherwise make safe to the satisfaction of the commission a borehole or excavation made during the course of prospecting operations. G. Unless the commission otherwise stipulates, remove within 60 days from the date of the expiration of the prospecting license a camp, temporary building, or machinery erected or installed and make good to the satisfaction of the commission damage to the surface of the ground occasioned by the removal. H. Subject to the condition of the prospecting license, expend on prospecting not less than the amount specified in the prospecting license, and 1. Submit reports of other documents to persons at prescribed intervals and supporting documents containing required information. 3. Monies required to be spent under subsection 2H and which are not yet spent shall be a debt to the Republic and recoverable from the holder in the court. 4. The holder of a prospecting license shall, to the satisfaction of the minister, keep full and accurate records of the prospecting operations showing particulars that the minister may prescribe. Section 38. Compulsory reduction of area of prospecting license. 1. Subject to this section, the holder of a prospecting license shall, prior to or at the expiration of the initial term, surrender not less than half the number of blocks of the prospecting area so long as a minimum of 125 blocks remain subject to the license and the blocks form not more than 3 discrete areas each consisting of a single block, or b. a number of blocks each having a side in common with at least one other block in that area. 2. Where, at least 1 month before the end of the term or within a shorter period that the minister may allow, the holder of a prospecting license satisfies the minister that delay by a government institution or agency in the issuance of permits or in carrying out a lawful activity have resulted in delay by the holder in the discharge of an obligation under the prospecting license. The holder may apply in writing to the minister for relief from the obligation to surrender land and the minister may exempt that holder from the requirements of this section, either wholly or in part, for a period, not more than 12 months and on other conditions that the minister thinks fit. 3. A dispute between the minister and a holder in respect of a matter that arises under subsection 2 shall be resolved under section 27. Section 39. Application for mining lease by holder of reconnaissance license or prospecting license. 1. A holder of a reconnaissance license or a prospecting license may, prior to the expiration of the license, apply in the prescribed form for one or more mining leases in respect of all or any of the minerals the subject of the license and in respect of all or any one or more of the blocks which constitutes the reconnaissance or prospecting area except that the blocks shall form not more than 3 discrete areas, with each consisting of a single block, or b. a number of blocks each having a side in common with at least one other block in that area, and each of which could be the subject of a separate mining lease application. 2. Subject to this Act and upon an application duly made under subsection 1, if the applicant has materially complied with the obligations imposed by this Act with respect to a. the holding of the lease, and b. the activities to be conducted under the license, the minister on the recommendation of the Commission shall, within 60 days of receipt of the application and subject to all obligations having been satisfied, grant the applicant a mining lease on conditions specified in the lease. 3. A dispute between the minister and a holder in respect of a matter that arises under subsection 2 shall be resolved under section 27. Skip sections 40 to 59. Special share to the Republic. Section 60. 1. The minister may by notice in writing to a mining company require the mining company to issue to the Republic a special share, by whatever name called in the company for no consideration. 2. A special share shall constitute a separate class of shares and shall have the rights that shall be agreed between the minister and the company, but in the absence of the agreement shall have the following rights. A. A special share is a preference share and shall carry no right to vote, but the holder is entitled to receive notice of and to attend and speak at a general meeting of the members of the company or a separate meeting of the holders of a class of shares in the company. B. The special share may only be issued to, held by or transferred to the President, the Minister, or another person acting on behalf of the Republic, and authorized in writing by the President or the Minister. C. The special share shall not confer a right to participate in the dividends, profits, or assets of the company or a return of assets in a winding up or liquidation of the company. D. The holder of the special share may require the company to redeem the special share at any time for no consideration or for a consideration determined by the company and payable to the holder on behalf of the Republic. E. Each of the following matters shall be taken to be a variation of the rights that attach to the special share, and shall accordingly be effective only with the prior written consent of the holder of the special share, which consent may not be unreasonably delayed or withheld or made subject to unreasonable conditions. 1. An amendment to or removal of a provision in the Constitution, regulations, bylaws, articles of association, or other equivalent document regulating th company which reflect or further the intention of all or any of the provisions of this section or of sections 51 to 60. 2. The voluntary winding up or voluntary liquidation of the company. 3. The disposal of a mining lease granted under this Act or a repealed law upon which mining operations are conducted or of the whole or a material part of the assets of the company which are attributable to the company's operations in Ghana but are not held in the country. 3. A mining company which fails to comply for a period of 2 months with a notice served under subsection 1 commits an offense and is liable on summary conviction to a fine not more than the cedi equivalent of $10,000. 4. A dispute between the minister and a holder in respect of a matter that arises under this section shall be referred for resolution under section 27. Skip section 61 to 71. Surface rights. Section 72(1). The holder of a mineral right shall exercise the rights under this Act subject to limitations that relate to surface rights that apply under an enactment and further limitations reasonably determined by the minister. 2. In the case of a dispute between a holder of a mining lease and the minister concerning the limitations determined by the minister under this subsection, the dispute shall be referred for resolution under section 27. 3. The lawful occupier of land within an area subject to a mineral right shall retain the right to graze livestock upon or to cultivate the surface of the land if the grazing or cultivation does not interfere with the mineral operations in the area. 4. In the case of a mining area, the owner or lawful occupier of the land within the mining area shall not erect a building or a structure without the consent of the holder of the mining lease, or if the consent is unreasonably withheld, without the consent of the minister. 5. The owner of a mining lease shall, in the presence of the owner or lawful occupier or accredited representative of the owner or lawful occupier of land, the subject of a mining lease and in the presence of an officer of the government agency responsible for land valuation carry out a survey of the crops and produce a crop identification map for the compensation in the event that mining activities are extended to the areas. 6. An owner or lawful occupier of land shall not upgrade to a higher value crop without the written consent of the holder of the mining lease, or if the consent is unreasonably withheld, without the consent of the minister. Compensation for disturbance of owner's surface rights. Section 73(1). The owner or lawful occupier of any land subject to a mineral right is entitled to and may claim from the holder of the mineral right compensation for the disturbance of the rights of the owner or occupier, in accordance with Section 74. 2. A claim for compensation under subsection 1 shall be copied to the minister and the government agency responsible for land valuation. 3. The amount of compensation payable under subsection 1 shall be determined by agreement between the parties, but if the parties are unable to reach an agreement as to the amount of compensation, the matter shall be referred by either party to the minister who shall, in consultation with the government agency responsible for land valuation and subject to this Act, determine the compensation payable by the holder of the mineral right. 4. The minister shall ensure that inhabitants who prefer to be compensated by way of resettlement as a result of being displaced by a proposed mineral operation are settled on suitable alternate land, with due regard to their economic well-being and social and cultural value, and the resettlement is carried out in accordance with the relevant town planning laws. 5. The cost of resettlement under subsection 4 shall be borne by the holder of the mineral right. A. As agreed by the holder and the owner or occupier as provided under subsection 3, or by separate agreement with the minister, or B. In accordance with a determination by the minister, except that where the holder elects to delay or abandon the proposed mineral operation which will necessitate resettlement, the obligation to bear the cost of resettlement shall only arise upon the holder actually proceeding with the mineral operation. 6. Subject to this section, the minister and a person authorized by the minister may take the necessary action to give effect to a resettlement agreement or determination. Compensation principles. Section 74, 1. The compensation to which an owner or lawful occupier may be entitled may include compensation for a. Deprivation of the use or a particular use of the natural surface of the land or part of the land. B. Loss of or damage to immovable properties. C. In the case of land under cultivation, loss of earnings or sustenance suffered by the owner or lawful occupier, having due regard to the nature of their interest in the land. D. A loss of expected income, depending on the nature of crops on the land and their life expectancy. But no claim for compensation lies, whether under this act or otherwise. E. In consideration for permitting entry to the land for mineral operations. F. In respect of the value of a mineral in, on, or under the surface of the land, or G. For loss or damage for which compensation cannot be assessed according to legal principles in monetary terms. 2. In making a determination under Section 73(3), the Minister shall observe the provisions of Article 22(a) of the Constitution, which states that, in the case of compulsory acquisition of property, prompt payment of fair and adequate compensation shall be made. 3. An agreement or determination in respect of a compensation to which an owner or lawful occupier is entitled, shall take account of payments and the value of benefits made or given to the owner or occupier in the past or undertaken to be made or given in the future by or on behalf of the holder and which are in the nature of compensation, including without limitation. A. The cost of resettlement. B. The annual ground rent, and C. Work that the holder has carried out or undertakes to carry out to make good damage to the land and improvements. Access to the court in respect of compensation. Section 75(1). The owner or lawful occupier of land affected by a mineral right shall not apply to the High Court for determination of compensation to which the person is entitled unless the person is dissatisfied with the terms of compensation offered by the holder of the mineral right or as determined by the minister under Section 73(3) or 73(5)(b). 2. The person entitled to be compensated or the holder of the mineral right may apply to the High Court for a review of a determination by the minister made under Section 73(3) or 73(5)(b). 3. In proceedings brought before the High Court under subsection 2, the High Court shall be exercising its supervisory jurisdiction. Provisions on small-scale mining will be a separate audio statute. Done.